Starting. Now I'm starting the recording. Okay. Now, before going to the session, I told you that Jan Vishwas Amendment Act has come. I have already given you a one table where it is mentioned the penalties and that. Just for your recall, it was in 14, I think. This was the offenses. So here what happened is, just taking it today only so that I can see. This is one question which I'm expecting. It can come. Whether it comes into descriptive, it should come under descriptive only. But yes, it can. There can be an MCQ also, because this is a new change, and patent office always goes for any new change. But please remember, the enforcement has not happened. Only this act, this has been notified. Because this notification needs some rules also to support the changes. That's why I have not seen any notification. If you get a notification, if you get, if you by chance you find that there is a notification for enforcing this, then please communicate in the group. That will be good for everyone. Now see the Jan Vishwas Amendment Act is amending various acts. It is amending too many acts. Total number of acts which it's amending is around what? 60? 41, 42. Total 42 acts they are amending, in which one is Patent Act. So in the schedule they have given all those amendments which are provided. In that, entry number 18 deals with the amendment of Patent Act. That was notified on 11th August 2023. The first question which comes to, if it is notified, why are you saying it is not enforced? The only thing is, please read this. Notification date and enforcement date can differ, because the Act itself says that the enactments are hereby, it shall come into force on date as central government may by notification in official gazette appoint, and different dates may be appointed for amendment related to different enactment mentioned in the schedule. So this is how it comes into force. It has been notified, but it has not come into force. Because different department will be dealing with the different acts, so they will come as and when they are comfortable. They will be providing you the enforcement date. That's how it will be get notified. Now, what is the purpose of JV Act? They want to decriminalize certain offenses and rationalize the offenses. This is what their objective is, what they are talking about, to amend certain enactments for decriminalizing, rationalizing offenses to further enhance trust-based governance for ease of living and doing business. This is the purpose. Then comes Section 3. This is very important. This is one important provision which generally has not been found with respect to penalties. This is where this is what he says is, whatever I have prescribed, whatever fine I have prescribed, that will be revised every 3 years, and the revision will what will happen? 10% of minimum amount will be increased, and after the expiry of every 3 years, 10% of minimum amount will increase. For example, if it is 1 lakh, 1 lakh now, after 3 years it will become 1,10,000. Okay, so this is what they have provided for in JV Act. This is a very, this is first time I have seen it, that someone has given already that fines and penalties will keep on revising by after the expiry of a certain period, here 3 years. Okay. Then now comes penalties. See, 109, 18 and 19 are same. 120 imprisonment was not there, fine was there, and this fine has been changed. Okay, this fine has been changed. So you can remember that 1 lakh has been changed. What has been changed is that there will be no imprisonment, but 1 lakh will become 10 lakh. And if it is a continuing offense, that means you are not complying with, you have falsely represented that any article sold by him is patented. Once I have penalized you, after that also, you are continuing claiming that, then 1,000 per day during the continuing of that offense will be the penalty imposed on you. Okay. 121, it has been deleted. But please remember, because see, two type of question can come. What Jan Aadhaar is, Jan Vishwas Act is providing for, how it is amending, or what was the position earlier and what is the position now. Both can be there. So for that, please, what is the position proposed under the Jan Aadhaar, not what is the position now. Okay, in 121, wrongful use of patent office word has been deleted. Now there is no offense called where you are using patent office as a if you are using word patent office and resulting in belief that business is a patent office, that will not be considered as an offense. Now come refusal or failure to supply information.
Excuse me, sir.
Yes,
Sir, your sharing screen is not visible to us.
I have not shared the screen.
No, sir.
Oh, sorry. I'm very sorry. I thought I'm sharing the screen. Thank you for bringing it to my notice. Okay. Can you now see the
Yes,
list?
sir.
Okay. So 121. So please, and I will be sharing this document to you. See here the whatever I have discussed purpose of JV Act. This is here. Then section 3. I have described. Here I am telling you this is notified on the date. What date it has been notified. This is also important. Which entry of schedule is deals with the patent act that has been given. This is the purpose of JV Act. This is how it is. Now comes here unauthorized claim of patent act. I have discussed this one, that no imprisonment was, there was no imprisonment, right? Earlier also there was no imprisonment, so hence yes, this is not relevant. But yes, 10 lakhs and 1,000 rupees per day for continuing offense. Okay, unauthorized claim of patent right. Then 121 is deleted. This one is red, marked red, is out. Then comes 122. 122 under section 105 and 146. This is 6 months. Okay. See, to the controller, this. What he is saying is, if you are not filing a statement, annual statement, then 1 lakh rupees will be the penalty. And even after the notification, you have after being penalized, you are still not filing 1,000 per day for continuing offense. Okay, imprisonment has been taken away. Okay, this 6 month has been deleted. Now comes, if you are submitting a false information, then the penalty is way higher. If we found that in subsection 1, this either under 100, you have to submit to central government, or under section 150-46, you are submitting the working statement. If you are submitting a false statement, then 1.5% of the total sale or turnover of the business or of the gross receipts in the profession, or 1 crore, whichever is less, that will be charged. Sorry, 1 crore. It's a 5 crores. It's not 1 crore, it's 5 crores. 5 crores, whichever is less, will be charged. Okay. Now comes when a patent agent is not liable for practice. Okay. So if he is not liable for practice, then yes. and still he is practicing. Earlier it was very less. It was 1 lakh and 5 lakh subsequent. Now this has been changed. It starts with 5 lakhs and 1,000 per day for continuing offense. Okay. This is the major changes with respect to penalty. One more thing which has been added, it is an administrative change. Administrative change is said that controller can ask any adjudicating officer to hold an inquiry and impose the penalty under this act. So any other controller any other person whom controller authorizes can inquire and impose the penalty after giving you an opportunity of hearing. In appeal, then any person above that adjudicating officer who has been authorized in this regard, you can appeal to that person. In this appeal process, you within 60 days you can appealing from the date of receipt of the order. Okay, once you have appealed, if you have failed to appeal in 60 days, you have to give that you have to provide that there was a sufficient cause for not preferring the appeal within that period, and your appeal may be admitted if the appellate authority is satisfied. Then comes, see, in every appeal you will be given a reasonable opportunity of being heard, and no appeal will be disposed of without that. Then appellate authority will dispose of the appeal within 60 days. So they are fixed with 60 days. 60 days is the limitation period within you have to appeal. If you appeal another 60 days from the date of filing of appeal, they will dispose it off. Then comes, suppose there was any order or after appeal there was another order. So you have to follow that order within 90 days. If you don't do that, then your penalty exists. Along with that, 1 lakh rupees or imprisonment of a term which for 1 year or both can be applied. Okay. So imprisonment is coming, but the offense is not the earlier one, but offense is now non-compliance with the controller of the order of adjudication officer or appellate authority, whichever the case may be. Then section 159 actually deals that central government can make rules. Since these two are the new sections, they have added that under these two provisions also, for this also central government can make rules. This is the new amendment. This is the new amendment or new proposal as per the Jan Vishwas Amendment of Provisions 2023. Now, this class. Okay, before going for the governmental use, can you tell me what is the patent right under section 48?
Using, selling, offering to sell, importing, and making. 5
Correct.
rights.
Very good. Then there is section 47, which gives you certain exception, which is called considered as conditions of patent. What are those?
Section 47 for government's own use. Government can making or importing that goods.
Correct. And there are two main things when we go for.
So for product and process both case, and for any medical or drug purposes, government can also import, and they can distribute that thing for hospitals or for government's own purpose.
Yes. And there is one more exception, which is not a government use. Which one is that?
So that is for research and education.
Correct. There is one research and education purpose. If you are using it, that is another exception. That is not an exception, but a conditions to your patent. Now, why I'm talking about is because when we are talking about government use, those conditions will not be considered as a government use. That's what this 99(3) talks about. Anything, any condition which has been, which falls on any use, which falls on the conditions under section 47, those government use will not be covered under this government use because they are anyway out of your patent right. Now comes
Say,
use by government.
Section 47 and section 9900 main difference is that 47 is only for government's own use. But 99 and 100 talks about for purposes of government. Government can use like this is it's for only government's own use, and that another 99 the government also can sell. Government also can get some royalty, and according to government can share with that patentee. My thought is like that. This is the main difference.
See, what I'm saying is that if there is a government use under section
Hmm.
47, that
Yes, sir.
government use is not covered under this chapter.
Yes,
This
yes,
is
yes.
what this is what 99(3) is talking about. Okay.
Yes.
Now, when we are saying, when we are talking in this chapter, which chapter is this? Chapter number, where is that? Chapter number 17, use of invention. 99 to 103 works here. This is chapter number 7. We are talking about chapter number 17. If in chapter number 17, please note what are the activities we are talking about. Made, used, exercised, or vended. What is vended? Vended means offer for sale. So this is the use. And then who is the government? They are saying three things. If three entities will be considered as government, if central government is doing, if state government doing, as well as the government undertaking itself. If for the purpose of this, if an invention is being made, used, exercised, or vended, it will be considered as it is being used by government or used for the purposes of the government. Okay. Now, what is government undertaking? Because central and state government, we all understand that. What is the government undertaking? Now, the government undertaking is, as defined under section 2(1)(h), government undertaking is any government department, any government-owned controlled statutory corporations, any government company, or wholly or substantially financed institution by the government. So, when I'm using for the purpose of government, use for purpose of central, all this, if for either of them it is being used, it will be considered as use for government. Now, same thing, making, use, import, distribution under section 47 is independent of this chapter. That is not covered under this. Now come the second part, 100. So 100 talks about, I will not go with everything. I will not be reading the entire statute, but the gist. See, the first thing it says that suppose after filing central government or any person authorized by central government. So I am using the short thing for that, PACG as an abbreviation, because it's too confusing for remembering every time. So CG or a PACG. In writing may use invention for government purpose after filing or grant of the patent. Okay, so after filing itself, invention can be used for the government purposes. Then comes second part. It says that suppose central government was using the invention before the priority date of the claim specification which you have, and the invention was duly recorded in a document, tested or tried by or on behalf of government or government undertaking. Any use of that invention or any person authorized by, any use by CG or PC, or any use by government G or person authorized by G, will be for that government will not pay any royalty or remuneration, because they know it even before the priority date which you are claiming. What is the exception is? Exception is that communication of if the invention was directly or indirectly by the patentee or the person from whom he has derived title. If he has communicated, then this free use will not be the position. Now comes the third part. Third part is says that if suppose invention was not recorded, tried or tested, then what will happen? So if central government is using your invention, then this use of invention shall be governed with as per the agreed terms. Agreed terms means agreed terms between you and the central government. You means patentee. Okay, patentee, applicant, whosoever is at that time, or High Court determined terms, or if there was a dispute and High Court has determined the terms, then those High Court determined terms, not more than adequate. But you will what will be paid is adequate remuneration, not what you are asking. So adequate remuneration will be the cap which will be given to you, and it will be decided taking into account the economic value of the use of the patent. This is how government will be using. So just for your understanding, government can use the patent, and if it has not been recorded, tried or tested before your priority date, then as per the agreed terms with you or High Court determined terms, and the compensation which they will be giving you is the adequate remuneration based on the economic value of the use of the patent. Now comes another thing is, suppose you are saying person authorized by the central government is using. So when this authorization should happen? Here government has complete liberty. Before or after the grant of patent, he can authorize. They can before or after give the authorization for the acts in which for example, suppose something was done without authorization, they can give the authorization with retrospective effect. Not a problem. That's what it means. Either before or after the act, in respect of which authorization is given order. It can be given to any person, whether or not he is authorized directly or indirectly by the applicant or patentee. Means irrespective of whether applicant or patentee has authorized or not, government can authorize anyone. So they have a complete freedom in authorization here. Now comes the another part, fifth part. It says that if government, where invention is being used by or with the authority of central government for the purposes of government, then the government will notify the patentee. And this notification will be as soon as possible. Okay. Notify as soon as practicable, as soon as practicable. And also providing the information regarding the extent of use of the invention as reasonably required. If suppose government undertaking is using it, government will call for the information from government undertaking and will inform the patentee. However, this will not work if in three cases: national emergencies, extreme emergency, or non-commercial use. Then comes another one, which says that although right to use, simple, because right to use includes right to make, use, exercise, and vend invention. Right to use include the right to sell the goods. On non-commercial basis, the goods are being sold, then it is fine, and the purchaser will deal as if the central government or person authorized by central government is the patentee. Now comes another one. Suppose there is an exclusive license. Before going for any explanation, please tell me if you understand the concept of exclusive licensing. What is exclusive licensing? Okay. Am I audible?
Yes, sir, you're audible.
Okay. Then the
Yes, sir.
exclusive licensing, let me go for the exclusive licensing. As we know, what is licensing? License is nothing but a permission. So when I say exclusive means that no one else has the permission to do that. And when I say an exclusive licensee, it talks about that even the patentee cannot do it. Though he holds the right, the right holder himself cannot do that particular act for which he has given an exclusive license. So that is an exclusive license. The exclusive licensee and non-exclusive licensee is, in non-exclusive licensee that there can be other licensee also. In exclusive licensee, there cannot be any other licensee. Even the right holder himself cannot practice that particular act which he has licensed for. Now comes, so he is saying, suppose there is an exclusive licensee or there is an assignee also. If that is the case, then notice of government use will also be given to exclusive licensee and assigner, not only the patentee. Now, third party rights. Third parties are who? Simple assignee, licensee. Anyone who has an interest in the patent will become the third party. In relation to this, it says, if use of invention is by CC, PACC or applicant patentee to the government order. Because of government order, this is being used, then any licensee, assignee and agreement, whatever you have agreed to in any agreement with respect to these three things will not apply to the government use. What is that? Any restriction, regulation of the use for the government. It will not apply. Purpose of invention or model, document, information of the invention. If there is any restriction or regulation of the use, that will not apply. If there is a provision of making payment with respect to that invention, that provision will also not apply. Then provision of the reproduction of the publication of any model or document connection with the said use, that will also not apply. And this will not be deemed to be an infringement of any copyright, substitution model or document. So this is how this is. That means government use is separate from any restriction imposed on any license, assignment, agreement, whatever the patentee and applicant has imposed on other person or from whom it is derived. For example, patentee has imposed it on a licensee and licensee is further licensing it to someone else to this. Then central government will not be bound by the restriction which are imposed on the licensee or other thing. Okay. Now, where the patentee or right to apply for obtain simple. If patent or patent application is assigned to patentee in a consideration of royalty, other benefits, then adequate remuneration. Suppose there is an assigner also. Then whatever the adequate remuneration is being provided, that can be divided between patentee as well as the assigner in agreed proportion as per the High Court direction. Now comes, if there is an exclusive license, then adequate remuneration shall be shared by patentee and such licensee in agreed proportion. Because whose interest is getting harmed? Licensee. He was running the royalty. He was earning the benefit. So adequate remuneration will be shared between patentee as well as licensee both. Then, and this will happen only in the case of exclusive license. We are talking about 102. 102 is acquisition of invention and patent by the central government. Central government can acquire invention, patent for public purpose. Please remember, for public purpose, after publishing a notification in official gazette, and invention and patent stand transferred and vested in central government. So for public purpose, they can acquire the invention by giving an official notice in the Gazette. Notice of acquisition shall be given to applicant, patentee, and interested person named in the register. We will give that. Since I have acquired, compensation will be paid. But this will be either agreed compensation or as per the High Court determination. And when High Court is determined, the High Court will determine by looking into the expenditure incurred in connection with the invention, turn, profit made, and other relevant factor, and then only the compensation will be decided by the High Court. Then comes to 103. This was acquisition of your invention. Then reference to High Court of dispute as to use for the purpose of government. Any dispute under section 100 comes, terms of use of government use, right of payment, amount of compensation, everything can be referred to High Court by either party. That means government can go, or patentee can go, or licensee can go, whosoever whose right is being disturbed, they can go. Then comes under this, if CG is a party, central government can ask for what? If patentee is a party, they will say they can ask for the revocation of the petition. They can ask for the revocation of the patent by a way of counterclaim. Your patent should not have been granted. And if patentee is party or not, they can always challenge the validity of patent without asking for the revocation. They can ask for invalidation of the patent. Now comes another thing. If there is a question record arises that whether invention was recorded, tested, or tried, as mentioned in section 100, and central government thinks that if I disclose this kind of information, it will be prejudicial to public interest, then such disclosure can be made confidentially to the advocate of the other party or any other mutually agreed independent expert. So confidentiality can also be claimed by the government on the ground that disclosure is prejudicial to public interest. Now, another one says that High Court, while giving you any benefit or compensation with applicant, patentee, interested person may have received, entitled to receive in respect of invention. So while deciding the dispute, High Court will look into the benefit and compensation which applicant, patent may have received or were entitled to receive, both. Then talks about another one is High Court may order the whole proceeding or any question or issue of fact to be referred to any official referee, commissioner, or arbitrator on such term as it directs. Okay, let it be arbitrated, let it be go to another commissioner. That's how it can happen. Now comes, if government servant or employee has invented, what will happen then? If the invention was invention was invented by a government servant or employee during the employment, and subject matter is certified to be connected with the work done in course of normal duty of the government servant or employee, then central government has a right to dispose of the dispute after providing an opportunity to hear such employee or the other interested person. They will hear and they will dispose it of. So this is the government use. I'd get MCQ can be there. Okay, MCQ can be there. Never seen a descriptive question on the government use. So not expecting a descriptive question, but MCQ, that too of 3 marker, yes, that can be there. Then comes some key concept. Some key concepts are compulsory license. What is a compulsory license? Any idea, any understanding without reading the definition? Okay. So in general, we say that there can be a license given. License is nothing but a permission. When government is giving you a license without the permission of the patent holder, then that license is called compulsory license. This compulsory license is not an exclusive license in any scenario. Generally, it's not, will always be non-exclusive license. Reason is very simple. I am giving a compulsory license because of certain factors, certain reasons which I have observed, a government has observed. Since those criteria didn't meet, I'm giving you a license. I'm not transferring your right. I do not want to take over your right. So you will have the right, and the person whom I'm giving is a non-exclusive licensee, so you can continue giving license to anyone else also. So compulsory license in general are non-exclusive license. Then comes access. When we talk about access, is that now see, there is one definition I would like to emphasize here: patented article. What is a patented article? Patented article in generally is considered as, it is an inclusive definition. It talks about patented any product or article which has been made by the patented process. That is the patented article. I have used some places, or during this process also I will use patented product as the product which has been patented, and patented article to refer the patented refer the product obtained by the patented process. Okay, just to differentiate between these two, I will be using it to make you understand faster. And if I'm referring to both, I will be using the word patented invention, which will include the goods as well as process as well as the product. Okay, now here the opportunity to obtain the patented invention is called the access. Now, access is always if you can afford this, if you can get. How the access can be bought? What are the barriers? It is too costly. The cost can be, or it is not produced in your area, non-availability at the point of service, or any other cultural factor because of which you cannot access. Right. So those are the criteria which create the barrier to access. Then there is another concept, exhaustion of rights. What is the exhaustion of rights? Exhaustion of rights is that once a particular property, all the rights of a right holder of IP are exhausted. Okay, when they have been duly sold. Duly sold means that they have been put in market by the right holder or any authorized party of who holds the intellectual property right. For example, suppose there is a product which you have bought, and the product was patented. For example, Samsung mobile, right? This mobile is patented. This has patented technology. You bought it. Now you own this piece. Now you have the right to do whatever. The right holder cannot ask you that after this, you have to use it like this, you have to continue do this. No, his rights are exhausted. I am not bound by any other thing. Okay. So once the piece has been sold, the rights of the patentee comes to an end. This principle is called exhaustion of rights. Then there is another concept called bioequivalence. Bioequivalence is basically related to the pharmaceuticals. So what happens is there is an original product and then there is a generic drug. So generally what happens is that once the drug is patented, so you also know that when the pharmaceutical, if you get a patent on drug, can you directly market it after getting the patent? No. The reason is there is another regulator. For example, here, Drug Controlling Authority. In US, FDA. So those authorities, what they do? You have to prove that your drug is safe for the purpose for which you are releasing this drug. You have to submit the data for clinical trial and other things. Okay. Now, this is you are doing because you have a patent. Now, the other party who is not holding any patent, they can create a generic drug. Okay. Generic drug means a substitute of your patented product. And that generic drug will be considered as your bioequivalent if in the same circumstances with the same amount, this gives a same amount, same kind of bioavailability. That is it is available in the blood in the same concentration. If that is there, then yes, these two drugs will be considered as bioequivalent. Then comes the Bowler provision. Bowler provision is nothing but an early working exception or regulatory review exception. As I have told you that in drugs, people can go for a generic drug or patented drug and start getting the approval from the regulatory authority before the patent expires. Okay, because they are not producing, they are not marketing, they are not doing. They are only experimenting, they are only testing, and this testing is done for the regulatory approval of the generic drug. So what will they do? So what happens is, suppose your invention is going to expire in 2024 or 2025, suppose. Let's take it as 2025. And the generic drug will start taking it, approaching the regulatory body and manufacturing, testing and everything, so that the moment on your patent expires, they can launch it immediately. So because of this testing and regulatory approval of generic version of drug, this testing is allowed. This is considered as an exception. This is also considered as Bowler provision in US. It is also called as early working exception or regulatory review exception. We will see whether this is allowed here or not. Then comes parallel importation. This Bowler provision, parallel importation, all are relevant with respect to infringement. Now, parallel importation. Parallel import means, as the name says, I am importing, someone else is importing parallel. I am importing because I am the patentee. I am importing it. But someone else is also importing without my permission. Now, the first thing is, then that parallel import should be barred. It should be considered infringement. Yes, it should be considered as infringement. But if suppose the patentee in India, suppose I am the patentee, I have the patent in India as well as US. Okay, I am importing it from you. I am getting it manufactured in US and importing. At the same time, I have also given a license there. There is a license producer. Anyone else is also buying the same product and importing it in India without my consent. But when he bought it, it was a legal buy. He has not done anything. If that happens, then what will happen is, if it is being imported in this territory, and this territory has a principle that the right are exhausted by after the first sale, then I as a patentee cannot stop him. So this parallel importation is allowed, because this parallel why? The reason is very simple. I have anyway made the money there, right? Because it was obtained from someone whom I have anyway authorized. So I have anyway obtained the royalty from them. So I should not get double benefit here. So this is the general common sense, because of which this people understand that patent holder should not be allowed to exercise his patent right in the importing country to prevent the parallel import. The only condition in parallel import is that the person who is importing, he is importing from the authorized person. Okay. That means where the consent of patent holder, where it was not illegal to manufacture that particular product. If I'm importing from that country, then this is a parallel import. Okay. There is a twist also here. Okay. The twist I'm not discussing because it will confuse you. Then going to the product and process patent. Product and process patent is, if product is patented, only the patent holder may make, sell that product. Nobody else can do so unless the patent holder has given the permission. For product patent, it's very simple. In process, what happens is, suppose there is a process. So I do not own the product. I only own the process. Since I own only the process, no one else can use this process. But that product can be made by any other process, which does not follow my process. Hence, in process patent, your process patent has a less protection than the product patent. And mainly in drugs, this is how the process patents are bypassed. I will use a different method of arriving at the same drug. And then your process patent does not make sense to me. It will not be able to protect you. Now comes working of patents and compulsory licensing and revocation. Revocation with respect to compulsory licensing. Otherwise, revocation we have anyway read. Now comes what are the other important concepts. Patented article I have shown. What is a patented article? In this chapter, when we are dealing with compulsory licensing, this is for that. Patentee includes the exclusive licensee. So they have considered exclusive licensee as good as patentee here, just for this chapter. That is working of patent as well as the compulsory license. That's the only thing. Okay. And what is the name of this chapter is? The chapter is considered as 16. This is the 16th chapter. Let me write it so that it is complete for you. Now, as I told you, patented article includes any article made by patented process. I have just devised my terminology just to keep the patented article, patented product for our reference different. Okay. Now, 82 talks about it, and now 83. 83 talks about the general principles applicable to working of the patented inventions. Okay. What are those principles? First thing, see, this 83 is important. This 83 forms the foundation on which a patent needs to be worked, on which a patent should be there. It gives an ideology on which India is operating its patent law. Okay. So the first thing it says that patents are granted to encourage invention and to secure that inventions are worked in India. You cannot do that. You are not working here and you are only importing it from other places where you have patent. And this working is also not merely working. They are saying working in India, and this working should be one, on the commercial scale, second, to the fullest extent that is reasonably practicable without undue delay. This is the requirement. I have highlighted this because this phrase you will find in most places, and this will form the criteria for granting a compulsory licensing or opposing someone else's license. Suppose that they are not granted. What is not our objective? I'm not granting to enjoy monopoly for importers. Same thing which I have explained earlier. You cannot enjoy a monopoly for importing. I'm the only one who will be importing, and all manufacturing is being done in somewhere else. That's not happening. Then comes protection and information of patent rights should contribute to what? Promotion of technological innovation, transfer and dissemination of technology, mutual advantage of producer and users, and it should be conducive to social and economic welfare and balance of rights and obligations. It cannot be that you have patented a drug, people are dying, but you are not decreasing your cost. Happening. If there is a need, it should be emphasized. Your patent rights should be exercised in such a way that society is benefited, and you also don't get harmed. See, it's not that you are enjoying a monopoly and you can do anything you want. No. The entire concept is that I have recognized your right of patent because I'm getting some benefit. I want to give my society some benefit. That's why I'm recognizing it. If your actions are not helping the society at large, then yes, you should not enjoy the patent right. The exclusivity, the right which has been given to you, should not be enjoyed by you. This is what it is. Now the patent granted do not impede protection of public health and nutrition. If suppose do not give you a public health and nutrition is not being supported by them, or promote the public interest, and they should promote the public interest, and they should be vital for socio-economic and technological development of India. This is our aim, that public health and nutrition should be secure, and public interest as well as socio-economic and technological development of India should be there. Then talks about patents granted do not. See, another very clear cut, if there is a need for public health, central government is not prohibited in any way by the patents. Then says patent right is not abused. You have got the patent right, but you are not entitled to abuse it. Abuse it means you cannot get involved in a practice which can be considered as unreasonably restraining the trade or having adverse effect on the international transfer of technology. So, restraining trade, you cannot restrain the trade unreasonably or have an adverse effect on the international transfer of technology. Then talks about the patents are granted to make the benefit of the patented invention available at reasonably affordable prices. You cannot have the prices, but invention cannot be so costly that public cannot afford it, because then public does not have an access to your invention. Now, 89 talks about there are other principles. What is that? General purpose for granting compulsory licensing. Same thing what we have discussed is here. They say that if you can approach the controller under section 84 to get the compulsory license, and the purpose of granting the compulsory license is simple. The patented invention are worked on commercial scale in territory of India without undue delay to the fullest extent as reasonably practicable. Same thing which we discussed earlier. Now, then he says interest of any person who is working or developing an invention in India under the protection of patent should also not be unfairly prejudiced. So these are the two general purposes. First, that it should be worked in India in commercial scale without undue delay to the fullest extent as reasonably practicable. At the same time, the interest of person who is involved in invention and working under the protection of a patent should not be unfairly prejudiced. These are the two very important principles. Now comes order for license. Suppose when the Controller General gives you an order for compulsory licensing, what happens? This compulsory license acts as if there is a license deed executed by the patentee itself or any other necessary party, whosoever is required. And this order will have terms and conditions, which for convenience sakes, I will be referring as TNC, terms and conditions. This is how, these are the principles on basis of which the compulsory licensing will be done. Now, let's go to the compulsory licensing and we understand how compulsory licensing works. See, very simple. Under section 84, any interested person can approach. Even licensee can approach. Who is the licensee? Licensee of the patent itself can approach. Okay. Yes. Now, licensee is the status of license or any admission license does not act as a stop. Whatever licensee, even if in the agreement it is that you should not have, you will never approach for the compulsory licensing, that restriction will not apply. So any licensee of the patentee himself can approach, as well as any other person interested can approach. What is the criteria when you can approach is after the date of grant, 3 years should have passed. After that, only for compulsory licensing you can come. Application will be filed in the form 17. In form 17, you will file statement of applicant's interest, facts, and term and condition of the license which applicant is willing to accept. You will tell that, okay, this is a TNC on which I'm ready to accept the license from the patentee. The ground, what ground you will be taking is that reasonable requirement is not met. The availability is not at the reasonably affordable cost, and third, that the invention is not getting worked in the territory of India. Okay, if you have done that, then under 87, section 87, controller considers your application. When controller is considering the application, then what are the criteria on which controller considers? These are the two criteria. Mainly, first, with respect to invention is the nature of invention, time lapsed from the date of grant, measures taken by patentee and licensee for commercializing this invention. At the same time, he will also look at the applicant, that whether applicant has the ability to work invention or not. Does he have the capacity with respect to capital risk which will be required for the working of invention? If yes, then yes, the applicant is worthy. Then comes another part is very important, that applicant cannot come to controller directly. He should have approached the patentee to obtain the license on a reasonable terms and conditions. And this effort has not yielded any result in a reasonable period. That means more than 6 months have passed from the date applicant has approached the patentee. If that is the case, all this will not be considered when there is a national emergency, there is a need for public non-commercial use, or patentee is engaged in an anti-competitive practice. Okay, done. Now, after considering this, if controller says that there is no prima facie case made, then he will notify the applicant, and within 1 month, the applicant can request for hearing, and if hearing is happening, the applicant will be heard, and controller will pass a speaking order to either refuse or allow. If he allows, then the procedure where prima facie case is made will be followed. Now, what is a speaking order? Yesterday we discussed.
So the order where the reasons for such an order has been given.
Correct. That is the speaking order. Now we come to the place where prima facie case was made and everyone was, controller was happy and satisfied that yes, there is a case for compulsory license. Now, he will ask the applicant or direct the applicant to serve the copies of application to patentee or any other registered person who is on registered and interested person. Okay. At the same time, controller will cause this application to be published. Within 2 months, patentee or any other person can file a notice of opposition in Form 14. What they will say, they will talk about ground of opposition. They will also provide the terms and condition of license which they are ready to accept. And if any, suppose they can say, no, my working is fine, I'm working properly. If they are fighting on that, they don't need to provide the terms and condition. But if suppose they are willing to give that license, but they have a different terms and condition, they can tell about that TNC also. They have to submit the evidence with respect to what the grounds they are claiming. And they will send a copy of this to an applicant and notify the controller of this service also. Once this is done, hearing can be arranged. After hearing, or all the opposition proceeding will happen, and then if it is if controller is of the view that CL should be granted, he will grant, otherwise he will refuse. If he is granting, what will he do? He can revise the terms and condition and grant the compulsory license, or he can refuse to revise the terms and conditions, and without revising that, he can give the compulsory license. Okay, so TNC which has been submitted to applicant by the applicant. This is how controller can give this. So when I'm saying compulsory licensing, terms of license, terms and condition of licensing is an important part which will form the part of the order of controller, and hence it will be exercised as if the license deed is being executed. However, can you request for the adjournment of hearing? Yes, under section 86, this hearing can be adjourned. We will see it a little later how this adjournment of hearing operates. Now we have heard that controller can grant. Now, while controller is granting, in 88, it is provided that if unprotected material is manufactured, use and sale is being prejudiced because of the license and purchase conditions, then also grant of compulsory licensing to such customer of the applicant can be given. Okay. Next comes if licensee of patentee is an applicant. If licensee himself is an applicant, order grant of compulsory license and cancel existing license. So they can ask for what? Existing license should be cancelled and compulsory license should be done. Or they can also ask for the modification of the existing license itself. That can be done. Suppose now this is a very different scenario. Suppose there are 2 or more patents by same patent. Some reason there is some patent and then there is other patents. If there is some patent we are talking about, a reasonable requirement is not met with this particular sum. But with respect to others, the problem here is that this patent cannot work, 2 or more patent, this cannot work without the license of other patents. So what will happen is, like this. For example, there are ABCD patent. For A, the reasonable requirement is not being met. A is we have approvals for compulsory licensing of A. But B, C, D license is also required for working of this. So what will happen is, license of these will also be granted to enable the licensee to work on the patent. So that will be done.
So that means compulsory license for A, B, C, D all will be given to the for compulsory licensing.
See, this is like this. I will give you compulsory license of A along with B, C, D to the extent they are necessary for working of this A. To the extent they are necessary.
Okay, sir. Got it.
You will not start manufacturing BCD. Right.
Right, sir.
You will be using BCD to the extent it is necessary to produce A. That's it.
Right, sir. Right, sir.
Okay. Now comes another part where it says suppose TNC settled by controller. Terms and conditions settled by controller is controller has granted a patent. Neat. If after 12 months pass, under Form 20, there can be an application for revision by the licensee. That is the person who has got the compulsory licensing. He can approach to the controller and ask for the revision. And this revision can be done in the Form 20. What are the grounds? He will take the ground why he is asking for revision. The grounds are mainly the terms and conditions which were imposed at the time of compulsory grant were more onerous than expected. On practicality, they are more troublesome. They are not simple. They are not easy to follow. Then comes unable to work invention except at a loss. And I cannot work invention except as a loss. So please allow me a revision of the licensing terms. If that happens, controller will again see if there is a prima facie case. If there is a prima facie case, it will go for the proceeding. If there is no, then he will notify the applicant, give him, he will have 1 month of time he can ask for a hearing. And if the hearing is done within 1 month after the notification, he can ask for the hearing. If a hearing is done and if he is refused, no revision of TNC will be done. However, if he have agreed, proceeding will go. If he is agreeing, he can revise the terms and condition. But this revision of terms and condition cannot be done second time. First compulsory license, then a revision. Later on, you again come and get it revised. That is not possible. Now, in 90, what are the terms and conditions of the compulsory license which are taken care of? First is the royalty and remuneration. Royalty and remuneration should be reasonable, and nature of expenditure incurred in making, obtaining, developing, and keeping that invention is considered while determining the royalty and remuneration. If patented invention is being worked to the fullest extent by licensee with reasonable profit, that will also be considered. That it should not happen that profit, the compulsory license is not having the profit also. A reasonable profit margin should be there. Then comes, and it should be worked to the fullest extent. Then this is that the product is being available to the public at a reasonable, affordable price. It will be non-exclusive license, and the licensee will not have any right to assign it. It will be non-assignable license. Then comes, it should be for balance of the term. Shorter if consistent with the public interest. So term we will try to keep it minimum. Minimal means it will not go beyond term anyway. And the term will be such that the public interest should get met. it should be considered the public interest. Okay, the predominant purpose of the supply may also predominant purpose is supply. Okay, you may also export if needed. Predominant purpose of supply is that may also export if needed. The exporting can be there, but main purpose is to supply. If suppose this compulsory licensing is being asked because patentee was involved in anti-competitive practice, then licensee will be permitted to export the patented product also. Now, if it deals with semiconductor technology, then to work the invention for public, not commercial use, this license will have this kind of a term. Now, if authorization for no authorization for import if such import will constitute infringement of right of the patent. So importing might not be allowed if it is constituting the infringement of the right of the patentee. However, government can direct controller to authorize the import of the patent article and product. If that is under that direction, controller will allow that. Now comes this is same revision of the terms and conditions. Compulsory licensing is there, at least 12 months have passed, request for revision of terms and conditions, no form 20 is done. As I've told you, the prima facie case is found, prima facie case is not found. If that is done, then he will direct the applicant to serve the copy to the patentee and inform. Then within 1 month, if patentee wants to oppose, they will give a notice of opposition under form 14, providing their grounds, evidence and copy to the evidence, and then same thing of your entire opposition thing will follow, hearing will be done, and if required, revision will be done, as discussed earlier. So this was the revision. Now, we are talking about the termination also here. Suppose compulsory licensing was granted under 84. Now, patentee wants that this compulsory licenses should go away. Now let it be terminated. So he can apply in form 21. Now he is applying in form 21. Again, he will give the ground, evidence, circumstance that led to grant. What he has to produce? The circumstances that led to grant no longer exist. And such circumstances are unlikely to recur. Okay. If that is done, then same thing, he will give a copy to compulsory licensee and approach controller, and within 1 month after receipt of this compulsory licensee, the licensee can object. If there is an objection received, then hearing notice will be received, will be given, and the hearing will be there, and upon hearing, controller can decide. This is the termination of compulsory license granted under 84. Now we are talking under 84. After 84, compulsory licensing, we are discussing 85. This is nothing but revocation. If compulsory license was granted, 2 years passed, sweet. Then any person interested or central government can approach and say that even after compulsory licensing granted, it is not being worked in territory of India, reasonable requirements are not being made, not available on reasonably affordable price. Statement, you have to tell what is the interest, what is your interest, and the facts. And Within 1 year, controller will take a decision whether to revoke or not revoke the license. Then comes adjournment part. Adjournment, please remember that there we said before hearing, adjournment can be asked for in 86. Now, what are the grounds of compulsory license adjournment? Compulsory license grounds were not worked in India, not worked on commercial scale to the adequate extent, or it has not worked to the fullest extent as reasonably practicable. If controller is satisfied that lapse time is not sufficient, it is insufficient, he can adjourn the hearing for aggregate of 12 months. We can give 12 months to the patentee to work in India and address the objection which are being claimed on basis of non-working in India, or on non-working on the commercial estate to the adequate extent, or non-working to the fullest extent as reasonable practicable. If reason of non-working is because of any applicable law or government order, then period of adjournment will start only after the expiry of such prevention. Second part is, if condition imposed on working or disposal of patented products or articles are used, cannot be the reason of non-working. You cannot say that these conditions have been imposed on the working or disposal of patented product and article or use, hence it is not getting work. That cannot be the ground. Okay, now we are coming to another part, another variation. Okay, 91 and 92. 91 talks about, suppose the controller can give you a license for related patent also. What is happening is, there is a patent 1 and there is a patented 2. Patent 1 is, patented 2 cannot exploit his own patent because of patent 1. Patent 1 is hindering the exploitation or working of the patent 2. That means there is some relationship between patent 1 and patent 2, because of which, unless patent 1 gives a license, patented 2's invention cannot be worked upon. If that is the case, then applicant can apply for grant of license by filing Form 17. Controller will conduct the proceedings, and if he is fine that applicant, now here what will happen is, it can happen that patentee of patent 1 also wants the license of patent 2. So the applicant should be willing to license its patent to other patentee also on the reasonable terms. If that is one condition which is satisfied, and before approaching, and patentee 2 should have made substantial contribution to establishment, development of commercial or industrial activity in India. If these two conditions are satisfied, then license can be granted. This license will be non-assignable except with the assignment of respective patents. For example, if any, that means you cannot assign this particular license to anyone. But if someone is selling that patent, along with that, this license will move. This is what can happen under section 91. Now we are going for 92. 92 is when central government is giving you the compulsory license. In this, there are only 3 criteria on which it can happen: national emergency, extreme urgency, or public non-commercial use. If that is the case, then declaration by notification, central government will declare by notification that compulsory license should be given for this particular patent. Controller, after this declaration or notification, controller will invite the applications, and on application by any person interested, any person who is interested can approach, and under the proceeding, as we have discussed, 84 to 87, this compulsory license can be granted. Terms and conditions, whatever the TNC will be for compulsory licensing, they will try to secure, their aim will be to secure the patented article are available at lowest price and reasonable advantage to the patentee. Comes Section 87 procedure is not applicable. We have said 84 to 87. 87 procedure will not be applicable if controller deems fit that there is a national emergency, extreme urgency, public non-commercial use is there, and public health crisis is related to AIDS, HIV, TB, malaria, or epidemics. If that is the case, then controller will inform patentee as soon as practicable and not conduct the proceeding under Section 87. What is the Section 87? That prima facie case, talking, asking, giving up opportunity to opposition. This will not happen. Now comes 92A. This is a very important part. See, compulsory licensing for manufacturing or exporting a patented pharma products can be there. And when it can be given if it is for export. Please remember, compulsory licensing for manufacturing and exporting of patented pharma products. It is related to only drugs. This compulsory license is given only if the exporting country has insufficient or no manufacturing capacity in pharma sector and there is a need to address the public health problem. One part. Or compulsory licensing has been granted by that country or has been notified for allowing import of patent pharma product from India or has published a notification that they will import the patented pharma product from the India. Then compulsory licensing for manufacturing or export can be allowed. If that is the case, then again under Form 17, you approach to the controller and controller will grant compulsory licensing. But this compulsory licensing will be solely for the manufacturing and exporting of the patent pharma product to such country, no one else. When we are talking about pharma product here, that means not only the patented article, but other ingredient necessary for the manufacturing as well as the diagnostic kit required. So all those will include pharma product and he will be able to produce all this and send it. There is only one successful compulsory licensing case. This is the first case in which NATCO versus Bayer, in which Bayer was manufacturing this cancer drug called Nexavar. This Nexavar, Bayer was asking for around 2 lakhs. Okay. And but NATCO was selling it at 9,000 rupees. Hence, this was allowed. And this is the first compulsory licensing case. And it was successful compulsory licensing was done here. And in this, it was in year 2012. Check the date. Most probably it is in 2012. That's what I'm remembering. Okay. So this is with respect to all the compulsory licensing which we have discussed, 84, 92, 92A, everything. Now we are going to talk about the infringement. You want me to continue or you want to take a break? Shall I continue? There is only two topics now.
Yes, sir. No problem.
Infringement and this. Okay, then no issues. Okay. So let's talk about the infringement. What is infringement? Any
Sir,
idea?
unauthorized use without
Correct.
consent.
If without, see, your right is that you
Hmm.
can prevent anyone from using, making, offer to sell or importing your patent invention without your consent. This is your right. If one is doing this without your consent, then yes, your rights are being infringed. Right. Now, what will not be considered an invention? This is the exception. Let's see. First thing is any act of making, constructing, using, selling, or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for time being forced in India or in a country other than India that regulates manufacture, construction, use, sale, or import of any product, then it is allowed. So it's not only in, that means you are engaged in these activity for getting a regulatory approval. This regulatory approval you might want to get in India or country other than India. Okay. Then this will be considered, you can go for, you are permitted to do that. The early working exception, you can say, bowler exemptions, you can say, safe harbor provision, whatever is, this is the place where we are doing it. Then B, importation of patented product by any person from a person who is duly authorized under the law to produce and sell or distribute the product shall not be considered as infringement of patent right. This is called parallel import. So this parallel importation is also allowed. Okay. So these two are the exemption. One is you are engaging in the use of patent, making, constructing, using, selling, or importing that particular patented invention for the reason of regulatory, for submitting the development and submission of the information to a regulatory authority. How comes suits? See, infringement is a court matter. Infringement does not come to the controller. Infringement will always go to court. Jurisdiction. Jurisdiction is that if there are these three types of the cases, there can be a declaratory suit. Declaratory suit that my actions are not infringing any patent. If I want that declaration, that comes under declaratory suit. This is a declaratory suit under 16105. Or someone is saying that you have infringed and you think that this is a groundless threat of infringement and it is only trying to pressure me, then you can go ask for relief under section 106. And the third part is, if there is an infringement, your patent is getting infringed, then you can file a suit. All this cannot be done below in any court inferior to the district court. So it should be a district court, most important. Now says that suppose there is a counterclaim for revocation. The moment a counterclaim for revocation has been made, then the suit along with the counterclaim shall be transferred to the High Court for the decision. Then district court will not hear this. Now comes burden of proof. So burden of proof. Burden of proof is what? That who will prove? Who should prove? In general, there is single concept. Who claims should prove. If you are claiming something, you have to prove. If you are claiming that you have a patent, then you should prove that you have a patent. If you are claiming that your patent has been infringed, then you should prove first that your patent was infringed. Then the burden gets transferred to the other party to prove that he has not infringed your patent. So this is how the patent proof works. So he's saying that if there is a process, so product we are very clear, right? It's easy. But what happened to process? Process where the subject matter of patent is a process for obtaining a product. And then this particular person cannot prove, right? A patentee cannot prove that whether you are using that process or not. Then court can ask the defendant to prove that his process is different from the patented process. And this difference, this will be asked only if the subject matter of the patent is the process for obtaining a new product. First thing. Second thing, the product which has been made, there is a substantial like that there is an identical product is being made by the process. And patentee has to prove that by reasonable effort they were not able to determine the what was the actual process which was used. Hence, you have to prove that you are not infringing, provided that patentee, a person deriving title of this. But what they have to prove first is that product is identical. You have to say the product produced by my process, by the patented process, and the process of the defendant is same. If you have proved this and then you have submitted that I cannot prove whether the process which they are following is same or not, then defendant will get the burden to prove that the process is not identical. In considering with now, court will not, while discharging it, court will not ask the defendant or anyone to disclose the manufacturing or commercial secret if courts think that this is unreasonable to ask. Then your manufacturing or commercial secret can be kept secret. Now comes what kind of a direction declaration. This is the declaration as to non-infringement. So 105. You can approach court and ask that any use of a process, making use or sale of an article is not, does not, would not constitute an infringement of a claim of patent. Okay. This can be done if the plaintiff has applied in writing. Plaintiff is the person who needs the declaration. In writing to the patent, before coming to the court, the plaintiff should have done what? Plaintiff should have approached the patentee and exclusive licensee and in writing asked for the written acknowledgement to this declaration and should have furnished him the particulars that this is the process or this is the product in question, which is this, and my use does not constitute an infringement of your rights. And the patentee or licensee has refused or neglected to give such kind of acknowledgement. If that has not done, then you can approach the court and ask for a declaration that your use, your sale, your making, your actions do not constitute an infringement. When you are going for a suit for declaration, all the cost will be paid by you. Whosoever is the party, you will be paying their cost as a plaintiff. Second thing, whether you get a declaration yes or no, validity of the claim will not be cast in the question. Okay. We are not declaring talking about the validity of a claim of a specification of a patent in a suit for declaration. We cannot challenge that. The only thing we are doing it whether my activity is infringing or not. I'm talking about that declaration. And once suit of declaration has been brought, this suit for declaration can be brought after publication of the grant. Once the patent has been granted, after that only you can go for a declaration of this under 105. Done. Now we are going to 106. Suppose you are getting groundless threat of infringement proceeding. What will you do? It says that you can approach this. What will you ask? You will ask for a declaration that threats are unjustifiable. Injunction should be given. Injunction is that stay, that the other person should be prohibited from threatening you, and any other damages which you have suffered because of those threatening proceedings, then yes, this is the prayer, this is the relief you can ask for. Now, What is the defense of the on the ground of patentee? Patentee has to come and prove, patentee or licensee has to come and prove that the actions of the plaintiff constitute an infringement of the patent or right arising from the publication of the complete specification. So you have to prove this. Now, here one thing is very clear. If someone has told what you are doing, please note that there is a patent exist with respect to that. This particular thing will not constitute a threat of proceeding within the meaning of this section. So clear cut, you should say that I will be taking action against you, and you think that your use is not violating, not infringing, then you can go for this. Use this section 106 for groundless threat of infringement proceedings. Okay. If suppose there is an infringement suit, what are the defenses which can be used? There are two defenses which you can use. One is the section 64 grounds, another is the section 47 conditions. If your act falls under these two, then under the conditions specified in section 747, you are not infringing. If under 64, you are following under that, then also you are not. On all the grounds on which the revocation can happen, that is the defense. So this is done. Now, relief. What is the relief in suit for infringement? Relief in suit for infringement is damage or account of profit or injunction. So three things can be the injunction, that to do or not to do a particular thing, either damage or an account of profit. So whatever suffered, if you have suffered something, you have suffered a loss, that will be considered as a damages. Account of profit, whatever the profits other person has made with respect to that because of infringement, that can be given to you. That is account of profit. Now comes, the court may also order that goods, as well as there can be order for seizure, forfeiture or destruction of the infringing materials or any other material which has been helpful in the infringement. Now come right of exclusive licensing. Please understand. In this licensee, license is a permission, right? So he does not have any right. He has only license. The right to sue also does not have. He will not have. But the act itself is giving a right to the exclusive licensee. Here, exclusive licensee can bring in the suit of infringement against any party as if he himself is a patentee and ask for damages, account of profit or any other relief. Now, second part is that what about the patentee? Patentee shall join this suit. If he has not joined as a plaintiff, he will be joining it as a defendant. But that patentee will not be liable for any cost. Why patentee should be joining? Because the patentee is a necessary party. He is the right holder. Licensee is only a permission holder. He is bringing the suit because his interest is being hampered. But patentee should be there to see to support his argument. Another thing, the patentee becomes the necessary party here. That's why patentee should be there. Then comes to the 110. What is the 110? Right of licensee under section 84 to take proceedings. Now, what about the compulsory licensee? Can he take this infringement? Okay. Compulsory licensing cannot go directly to the court and sue other person. Reason is compulsory licensee is a non-exclusive licensee. But since he has got the compulsory license, he can ask patentee to take action. If patentee refuses or neglects to do so, then after expiry of 2 months, compulsory licensee can go for instituting the proceedings of the infringement in his own name. Same thing will apply here. Patentee will become a defendant, but he will not be liable for the cost. Now come the restriction on power of court to grant damages or account of profit for infringement. So if damage or account of profit is going to be awarded, it has proved that you have infringed, you have only one ground. You can say, I was unaware and there was no reasonable ground for believing that patent was existing. Okay. Now, in this, the other party will say, I have written the patented there. I have written patent on that particular packaging. Everywhere it was written, it is patented product, it is a patented product. Please understand, only the application of an article of word patent or patented written on any packaging or anything will not imply that patent is obtained on the article unless you are giving the number of the patent. So if you want to claim that you have informed adequately the other party and the person should not take this plea that patent was not existing, he has no awareness, then you should print number of patent on that patent product or patent article. Okay. Then comes second part, where it says in suit of infringement. Okay. This too is talking about the cessation period. If any infringement is happened in the cessation period, you will not be allowed to get the damages or account of profit because the right itself was in suspended mode because you have not paid the renewal fee and other things. Okay. Now comes third. This is regarding the amendment of it. Suppose an amendment specification was amended. What will happen? Will you get the infringement damages for the infringement before the amendment? So he says no. Before the date of amendment, you will not get the damages or account of profit. However, you might get if you can satisfy the court that the original specification was framed in good faith with reasonable skill and knowledge. This good faith can come to rescue you in the event of infringement of the amended specification. Okay. Court has no restriction on giving any injunction in any suit for the infringement of patent. So there is no restriction on that under this section. Now comes certificate of validity of a specification and cost of subsequent suit for infringement thereof. This 113 is again very easy. It says that suppose there is a 64 or 104 proceeding. 64 is a proceeding of revocation and 104 the revocation is requested by the government, right? Then the validity of any claim of the specification is contested and the 104 is the infringement proceeding in which you have counterclaimed, right? Yes. Okay. Sorry, I have incorrectly mentioned that this is a government revocation. 64 and 104. 104 is the counterclaim in the infringement. Okay. In that you have claimed for revocation. Now, suppose you have contested. High Court examined the claim and declared that this claim is valid. Okay. Then High Court can certify. You can ask for certification that this claim was valid, was contested in the proceeding, and the validity of this claim has been upheld. So this validity certificate, if you have that validity of a specification or claim certificate you have, then suppose there is another infringement suit, you have involved in another infringement suit, then what will happen is someone else again comes for the revocation. The other party says, okay, we will go for revocation of the patent. And then the patentee, the claims obtains the final order in judgment and the patentee wins it. Then he is entitled to get all his full costs, charges, and expenses of incidental to any such suit or proceeding properly incurred. Because of this certificate of validity, he will be able to get all the costs, charges, and expenses which were done by him with respect to the suit or proceeding properly incurred, if he wins. Now, defense is simple. That you have lost, but you do not want to pay the full cost, charges, or expenses. So the defense is simple, is that you were unaware of the grant of the certificate. That's why you have challenged it in the revocation. And the moment the dispute was disputes were done and you were aware of the grant of the certificate, you have withdrew this defense, that revocation one, for that valid claim. So if that is the claim, you say that I have already withdrawn it, then he will not be entitled to get the full cost. Now comes 140. Infringement of partially used. Suppose there is one claim is valid, another claim is invalid. What will happen to your injunction? What will happen to your infringement suit? Court can grant relief only with respect to valid claim. Invalid claim, you are not entitled. So here what will happen is that they cannot grant relief except by the way of injunction. So they can only give you injunction, not the damages or cost, except in subsection 2. Now in subsection 2, what happens is, if patentee proves that the entire claim was framed in good faith and with reasonable skill and knowledge, then court can grant relief with respect to valid claim for the cost and damages and account of profit. So understanding is simple. There is a valid, there is an invalid claim. Invalid claim, though, you are not getting anything. Invalid claim also, he is not going to give you any account of profit or other thing unless you prove that the claims were framed in good faith and reasonable skill and knowledge were used. Otherwise, you are only entitled for the injunction, not for damages, not for the cost. Okay. This is done. Now, this is the last piece of our lecture. Suppose you are going for a license agreement. Okay. You all will be involved in a drafting of license agreement in your professional life once you are doing. If you are engaged in an educational institution, you might get to be involved in the negotiation of the licensing agreement. So that too of the technology transfer. This 140 is very important for the technology transfer agreements, because generally what in technology transfer agreement is what? Nothing but the transfer of intellectual property in patent. That is what is getting transferred along with some other technology which has been copyrighted as a form of software or other thing. So these two are mainly the pillars of technology transfer agreement. Now in technology transfer agreement, now here, what we are talking about, suppose in licensing or in there, he is talking about three things. There can be a contract for sale or lease of what? Patented product, patented process, anything. Or there can be a license to manufacture or use. That is also fine. Or there can be license to work any process protected by a patent. Then what will not, then there can be some restrictive conditions. And if those restrictive conditions are being imposed, these will be considered as null and void. That means they will not have any effect. Because 140 says that those restrictive conditions are not allowed. They will not be enforced. They will be as good as not present in the agreement. What are those? First is any condition which requires purchaser, lessee, and licensee is talking about this. Because their contract for sale, he's a purchaser. If he's a lease, then he is a lessee. Otherwise, he is a licensee. So he's talking if it is required to acquire or he prohibits from acquiring or restricts the right to acquire anything any non-patented article or non-patented product, this condition is void. So there can be no restriction on the non-patented product or non-patented article. Okay. Then comes second part. Agreement cannot prohibit or restrict the right to use an art and to use a non-patented product or patented article. You cannot prohibit him also for that. First is you cannot require to acquire that. This you should acquire from me. Huh? Okay? You cannot do that. Same thing, you cannot ask him to not use something which you are not supplying. Now comes, you can also not prohibit from using or restrict the right to use any process other than the patented process. That also you cannot say. Then comes three things more. You cannot ask him that if anything else is you are developing, then there should be exclusive grant back. You will only give me license, no one else. This exclusive grant back like condition cannot be there. Second, prevention to challenges to the validity of patent. You cannot ask that since you are my licensee, you cannot challenge the validity of patent in any suit, anything. This, if you are asking, all is null and void. Coercive packaging license. If you are asking for coercive packaging license, that will also be considered as void. Now, let's understand what coercive packaging licensing means. See, coercive packaging licensing means I have a license of one patent. And there may be requirement of licensing more than one patent in order to commercialization. If you are asking me, forcing me to get a license of multiple patent while those are not needed, then yes, this is called coercive package licensing. All the license for multiple patent will be considered package licensing, and since you are not allowing me to choose, it will be considered as coercive. So the entire such package licensing shall be by volunteer. That means I should have an option to say yes or no, and with the consent. If licensor is forcing licensee to take the license for the patents, even if it is not required by licensee, then such license is called coercive package licensing. You cannot say कि मेरा ये license ले रहे हो इसके साथ ये भी लो, नहीं तो नहीं देता. If you are saying that, so the other party will agree and then will work as if that condition does not exist in the agreement because of the effect of section 140. Grant back process is a licensing agreement which helps a licensor to ensure the licensing out patents covering its technology. Any improvement by the licensee are granted back. Okay, so same thing. Okay, I have given you a patent, you went for an improvement, this improvement you got a patent, you license me back. But this you cannot ask for exclusive license back to you. Okay, so these conditions are there, then there is no condition. This is void. Now, you cannot become clever and say licensing agreement is separate and this restriction agreement is separate. You cannot create this kind of thing, and you cannot go for this and say that these two are unrelated. It will say condition of nature, this ABC shall not cease to be a condition. That means even if there is a separate agreement, we will consider that this is the same agreement. Okay. So you cannot try to bypass this by entering into a separate agreement. Now comes third. In proceeding against any person for infringement of patent, it shall be a defense to prove what? That at time of infringement, there was a force in contract enforce a contract relative patent and contain a condition declared unlawful. Okay, simple. So if there is an infringement of patent proceeding against this is a defense. You can say that these conditions were there, and hence this I'm not infringing the patent. This you can always ask and use this defense. Then says that provided that this subsection, this will not apply if the plaintiff is not a party to the contract. If you are not even a party to the contract, you cannot talk about that. And proves to the satisfaction that restrictive condition was inserted in contract without his knowledge. And if he can prove that the restrictive condition was inserted without his knowledge and consent, then yes, this will not act as a defense against the infringement. This section is not prohibiting what? It will not affect a condition in contract by which a person is prohibited from selling goods other than those of a particular person. I can always say that you will not sell goods of anyone else except me. That is valid condition. Second, validate a contract which, but for this section, should be invalid. So this section is not affecting any of that condition. It's not also validating a contract which would have been invalid except for under this section. Okay. And third is affect a condition in a contract for lease of or license to use a patent article by which the lessor or licensor reserves to himself or his nominee to right to supply new part. See, supplying new part for patented article or to keep it for repair, that can also be in a condition, and this section does not stop that kind of condition to be inserted. So this is the entire patent syllabus we have come.